I'd like to call to order the November 5th, 2014 Special Planning Board meeting. On tonight's agenda is Rudy's site plan amendments. The Planning Board will discuss possible research to be conducted as part of this application as a result of advice from our town attorney, John Wall. I don't see anyone from the public. I was going to say that public comment period will be opened after the Planning Board Chair has described the policy issue under consideration, and then members of the public wishing to address the board concerning an agenda item shall wait to be recognized and be able to come up. Once again, there is no one from the public here. Each member of the public would be allowed 3 minutes, and such time may be extended at the discretion of the chair. The chair may decline to recognize any person who has already spoken on the same agenda item, and once the public comment period is closed and the planning board has begun its deliberation on an item, no member of the public shall be permitted to address the planning board. As this is a special meeting and it's not a public hearing, I will also be limiting comment from any representative from Rudy's to the 3 minutes. At this time, Henry, I recognize you.
Thank you. As you no doubt know, I was unable to attend the last meeting, and so I reviewed it on the town's video playback, and I listened to most of the recording, or 90% of it. On the initial remarks from Rudy's, I noted that it was stated that a gentleman or a person had had words with Mr. Woods over trespass. That, in actual fact, I would like to make clear, was myself. I, in actual fact, this was over about 6 to 6.5 years ago, approximately 6.5 years ago, I'd had words with Mr. Wood. And after those few words, I never actually spoke to him or had any business with him until such times as Rudy's came up originally for planning application. I made the statement to the board at the time that I had had words with Mr. Wood, and I was asked if I could be impartial, and I, of course, said, yeah, I've no reason to be any other way. Having words with somebody doesn't mean you dislike them or something wrong. And the board listened to what I said and said there seemed to be no problems, and so I went ahead. It should be noted, of course, that I actually voted in favor of the development, so obviously I bore my impartiality was shown because I declared it fine. I noted as well during the review of this that it was said that we were in the review or research, we were like some sort of judicial board. Well, it seems to, like a trial thing, and that we should not do any research on our own. But it seems to me that we were requested to be part of the board because of certain expertise. There's an architect on the board, I'm a programmer on the board, a couple of lawyers and solicitors, lawyers on the board, so that every one of us has certain, and a farmer, I do apologize. And so every one of us has some specifics and has knowledge that is individual, and so as long as it seems to me that we transmit it to the rest of the board, it's okay. Anyway, I made that statement in terms of full disclosure, and so I feel that I ought to make it again and answer any questions or whatever, but I feel at this present moment that I have no biases and I can be impartial, but the rest of you should decide whether you wish to ask me any questions or not, obviously. Thank you.
I appreciate that, Henry, and I would also note, besides voting in the affirmative, you also sat in when the amendment, I'm going to call it the bump outs, everyone might remember, with the kitchen. And how did you vote on that, remind me? You voted also to
yeah,
amend
in
the
favor
plan
of it.
on that one?
The only questions the questions I asked were,
But you did vote in the affirmative,
Yes,
right?
I am
So,
voting in the
okay,
affirmative.
just as
That's
a
fine.
reminder that we have seen this project come back for amendments, and besides voting in the affirmative,
Yeah, and it's,
the original time you have with the other amendments.
and
Yes.
just to add to
Okay.
this, nothing was ever restated about any words I may have had.
Right, I just
Was
showing
all-
a pattern
yeah.
that you certainly have voted, I think those have all been votes
Unanimous.
unanimous,
yeah.
yes, yes.
And so I just one other thing. During a workshop, and then of course it was quoted that in the statement that I looked at, that it was an aggressive or a negative review of the last workshop. I didn't think so. They were just normal questions as far as I thought at the time. That's
Okay,
my
thank you, Henry. All right. At this time, then, actually, it says that the chair would describe the project, but Maureen, would you mind describing that project, or the policy? Yeah,
I'd
not
be
the
happy
project,
to, but I
excuse me.
am going to ask the board that Mr. Steinberg has declared that he has no bias, but it's a finding of the board on whether or not a board member can participate in an application.
Yes, go ahead, Caroline.
In all of our deliberations on Rudy's, I have not seen any sign of bias from Henry. So I do not think that there's an issue with him continuing to hear this item.
Thank you. Any other comments from anyone else on the board?
Do we need a motion? It says something
It-
about a vote. We have to-
There should be either a vote or a motion or some kind of consensus from everyone. Usually what the board does is they say, yeah, everybody, we think it's okay.
Victoria, my memory is a little weak in this. Did the applicant actually levy a charge that the unnamed person had biases against the applicant and was asking that the person recuse themselves? Or was it more of a softer statement?
I believe there was a question raised about bias of an unnamed planning board member.
Right.
Okay, yeah, my reaction, I think we should vote affirmatively, either to have Henry continue to sit or recuse himself.
I have one question.
Yes.
The applicant also said that maybe there was some trespass, and it sounded like there was some conflict around that. At Rudy's, did that involve you, Henry?
Do you want me to?
At Rudy's?
Sorry, at what?
Inside the chain link fence?
No.
No.
Nothing to do. What in actual fact happened was I will give you this slight history of this. I purchased the
Yeah,
property.
Henry, if you're all set, we can just take.
I just want to know if you were the one who allegedly trespassed.
Oh, no, it's nothing to do
Recently.
with, anything to do with the
Great,
site
that
whatsoever.
was my only question.
In fact, that was answered, if you look at the review, it was answered by somebody else on the
Okay.
board.
So I just want to remind the board, and I'm going to read from the Maine Municipal, that part of under bias says various court decisions also have established a rule requiring a board member to abstain from the discussion and the vote if that board member is so biased against the applicant or the project that he or she could not make an impartial decision, thereby depriving the applicant of his or her due process right to a fair and objective hearing. So if you feel that Henry cannot abide by this guideline, then I would ask, if anyone wants to say that they feel that Henry is biased. Otherwise, I'd rather take a vote in the affirmative instead of the negative. So if everyone wants to keep, I'm not really sure how to word this, but if
It's
a finding of non-bias?
It's a finding that there isn't a affirmative finding of bias.
Okay. There's not a affirmative finding of bias. Does everyone all in affirmative? Okay. All right, then that was unanimous, and
I do want to clarify something, though, for Henry. So my understanding of what the applicant said that night is even though it wasn't Joe, he was not talking about Joe when Joe was driving by trespassing, I believe the applicant alleged that it was somebody else who trespassed inside the chain link fence.
No,
It was
it
not
was
Joe.
not
No,
Henry.
It was not Henry.
It was not Henry.
Yeah, okay. I thought you said if I had looked at the tape, I would have seen that it wasn't you.
All right, so that addresses the issue. Thank you very much for bringing that up on, but we really want to discuss research to be conducted as part of this application, because we did receive a letter from our attorney. So, Maureen, at this point?
Thank you. So at the last meeting, there was concerns raised regarding potential due process violations. I have provided you with a letter from John Wall, the applicant, I believe. No, you have not. The applicant has not received this letter because it is titled privileged and confidential. I do believe at this point we will just add it to the file and it'll be available for anyone. However, one of the 3 items raised was a question about research, specifically internet research. And in order to assist the board with staying on the right track and not in any way infringing on the applicant's due process rights, one of the recommendations that was made was to have a person, one person, be designated as the research person for the planning board. And that's what tonight's meeting was about. The planning board making a determination if they would like to identify one person as the person who would be the collector and potentially the person who does the internet research. I think the main piece here is it's important that if there is information out there that a board member has obtained or is interested in, that it be collected all by one person, and then that person would be responsible for making sure that every board member has that information, that anything the board receives, the applicant would also receive, and that that information would also be placed in the file. And that is an effort to respect the right-to-know law, to respect the town's very strong, open, transparent policy, and the town council's communication strategy. So that was for that reason, and because it was raised as a concern by the applicant, this special meeting was called by the chair so that the board could make a decision in a public meeting on how they want to handle this. I'm going to turn that back over.
Okay, thank you. We did have in this letter from John Wall, the attorney, saying that the town planner would be the obvious choice. Unless anyone else has any other comments, questions, Peter?
Yeah, no, I think his point is a good one, and Maureen, I think sometimes has better things to do than becoming a research engine, although I'm sure she'd do a great job. If I could put a slight spin on what he said, it seems to me the person he's talking about, I think it's a good idea, is more a clearinghouse for this information. Maybe the person does generate it through their own research, but even more importantly, will be the clearinghouse for other members who may have read an article on a topic of interest, so that the principles observed, the information will be accumulated, made available to the board, eventually made available to the applicant. I think it's a little unfair to put the research obligation on one person, which sometimes it just may not be practical or convenient. Sometimes one person might be better suited to do it than somebody else.
Okay. Yes.
I agree with Peter's point that A, it's a great solution from John Wall, and B, it's too much of a burden on the planner, and I like the clearinghouse model. I do think we should have a timeline for when this material gets collected and distributed, so the applicant has time to respond to it, like maybe a week before the hearing. What do you guys think about that?
Other thoughts? Peter, I saw you first, and then I saw Joe, and then I'm sorry I didn't turn my head, but I'm going to go Peter first, and I saw Joe, and then I'll go Henry.
Actually, I'd rather get your question answered before I make my comment.
Oh, you have a different comment? Yeah, I'd still like to, you did ask for the board's comment. Peter, is this directed towards Liza's comment
Well, let's
about
get Liza all
timeliness?
taken care of, and then
Okay. Liza had a question about timeliness. She wants to make sure that the applicant has the same amount of time, amount of time to look into this, and she's saying a week. Normally, we have, yeah, go ahead.
And I just want to point out to the board that you get the package from the applicant a week before the meeting. And if there is a burning need for research, it seems like there ought to be time to read the applicant's information and then demand research. I also would point out that you receive letters from the public right up until 4 o'clock, the day of the meeting. So I think that a deadline would be nice, but I would suggest that you make it much, much closer to the meeting so that it lines up with the correspondence. We don't have any deadline for the public getting correspondence. The reality is that if they send it after 4 o'clock, the odds of it getting to you before the meeting are pretty low. But what I would suggest is that whenever you get the information is when the applicant would get the information. So if you do set a deadline, I would set it like the day of the meeting or the day before the meeting, and then the other condition is, like public correspondence, you receive it and the applicant receives it at the same time.
And I saw Elaine first, and then we can do Henry.
I just wanted to respond on the timing. I would not suggest that we put a specific deadline of days. We frequently get information from applicants presented the night of the hearing. We get plans that are on the board that are different from the plans we have in front of us, and I think that's a very valuable flexibility. And obviously, if we're going to be getting these materials right up to the time of the meeting, we have to be able to respond. But the other thing that we always do is if we get new material, we always are in the position to say, well, that's really interesting, but it has come in too late for us to then be able to move forward and make a final determination. And the applicant similarly could say the same thing, that we are presenting material that they can't adequately respond to, and therefore they would have time to say that. And I agree with Maureen that the information would be distributed to everybody essentially at the same time, but I wouldn't put a particular number of days or 4 p.m. or anything else. I think that will tie hands in both directions, and I don't think that would be in the benefit of the applicant applying to them or to the benefit of the planning board to reaching good decisions.
I'm thinking then on this is that we normally receive our package of information around a Wednesday or a Thursday. And we need to digest all that information in that type of a time frame. But once again, we do get a little bit more outside of that time frame. But we do get the bulk, and we are expected to digest this. And I'm thinking that might be when the research that's going to be conducted comes out to planning board members and to the applicant. So kind of keeping things where...
Can I interrupt, please?
Go ahead, Andrew, you can interrupt.
I thought this was the internet age, and I note that if we ever send any information, it normally is taken by Maureen and distributed to us. It would seem that if we had a section in the Cape Elizabeth webpage that we all posted to, would be available to anybody who wanted to look at it and anybody about. So in other words, I said, this is great, this is bad, somebody else could disagree, but look at, you don't like the idea I see from your face, but on the other hand, it would be available to us all at any time.
I do have this pained look. Would anyone like to put it into words?
Obviously, the chairperson doesn't like the idea.
Use your microphone, please, and I'd like to hear comments.
I just want to make the comment that we're talking about research as if it's something that is commonly done, always done within certain timeframes. You certainly don't start thinking about a particular item until you're sitting and reading the submission for that particular meeting. So I don't know I want to research something until I may not know until I'm reading the submission. Gee, I got a question about this. Do I call Maureen and ask her, or do I do a little quick study and see what's going on and try to get some information, or do I write a question that I then bring to the meeting and ask the applicant? I'm reading this, I don't understand it, I'm curious about what else might be available. Help me out here. All of those things could happen.
Yeah.
And all of those things have happened. And I do 100% agree that any research that that anyone may do should be made available to the entire board and the applicant in as timely a way as possible. But sometimes that timeliness is the Sunday night I'm reviewing the packet before the meeting. I may not review it on Wednesday when I get it. I don't necessarily take the whole week before. So, and I think we're trying to make this way black and white, and I just think it's a matter of common courtesy and a matter of appropriate dissemination of information. And that's where I come from on this. I think it's a mountain out of a molehill.
Any other comments before I turn my head? I don't want to miss anyone. Yes.
Yeah, moving along with Carol Ann's point, we had a very unusual situation here, and sometimes unusual situations are not a good catalyst to come up with a general rule. The whole idea of research, I think the applicant's counsel seemed to be suggesting that we were all running around on our own doing all kinds of intensive research so we could get facts that we could hold to ourselves and form our own opinions. I don't think anything could be further from the truth. We had a situation with a product. I think most of us here were unfamiliar enough so we at least wanted to be able to ask intelligent questions. The only research I did was along that line. I checked the websites that they had in their own submissions and looked at Wikipedia, which is not exactly a super source of information, but not to gather facts from which I would form an opinion, but really to find out what kind of questions should we be asking. And I find it extraordinary that now on 3 occasions, we ask some of those questions and have yet to get a response. And if the applicant is saying, gee, we shouldn't have had the information in the first place that we generated, then I take it all we're allowed to listen to is what the applicant tells us, which would have been that Corton is the greatest thing since sliced bread. And I just think we have to apply this whole thing reasonably. We should submit any articles, websites we found that we found interesting and that spoke to the issue through this clearinghouse approach and get it in everybody's hands as soon as possible. But to come up with a hard, fast rule on, quote, research, whatever that is, I think it's a mistake. I really do.
Okay, thank you. Henry, I did want to just address this, using the internet to speak to. I want to address your point about being able to maybe share information and maybe speak to each other. I'm not sure if
I suggested an internet.
No,
thing.
okay. I want to make sure that anything leaves Maureen's office at the same time that everyone receives it and the same time the applicant receives it. And as normal, we never, ever are sending each other emails.
No, I didn't
or
suggest
discussing.
that.
Okay,
I suggested
then I
the
heard that wrong.
clearinghouse basically be
Okay.
a website, which is, I looked at this, could you comment on it? I mean, that's going to be the normal thing. I mean, you're not, I see so-and-so and so-and-so, I'm going to ask a question about it. Or, if there's a person who's the clearinghouse, my estimation, it shouldn't be a person, it should be a page, but an internet. Then it's accessible to everybody the instant it's put on there.
Elaine.
My recollection is that the town of Cape Elizabeth tried having an open website at one point. I can't remember how many years ago it was, and it was a disaster. I think it crashed. There were inappropriate things posted, and the town having an open website. I think that the town council voted to take it down very quickly, but maybe, Maureen, you can remind us more of what happened?
Not that quickly.
No, not quickly enough, okay.
But I think what Henry is talking about is, using technology versus a person, and I would suggest that the mechanism that you use be something that you could just discuss when you periodically review your rules and your procedures. Right now, whenever you get your package, all the memos and the written materials are also posted to the town's website. So the kind of thing Henry's talking about, I wouldn't want to do it right now, just because there's some logistical things we need to work out. But longer term, I mean, that is something you could do. It's just a different way of getting information out. Right now, what I would do is I would email it to the planning board members because that's the quickest way. If anyone wanted it in paper, I would give it to you in paper. I would email it to the applicant at the same time the planning board is getting it, and I would put that information in the public file, which is why my files always look like this. So Henry's just saying that instead of emailing it to you, I would say, check the webpage, I've added new information. So I don't think we want to do that now because of logistics, but certainly it's an option for the future.
Okay, Elaine?
It seemed to me, I kind of read through John Wall's letter, and he made a suggestion that we do make a designation. And I think perhaps we should handle this in 2 steps. We have an application before us where a request has been made on this specific point with respect to this application. And I would suggest that we address that tonight just for this application. And I actually, in the half hour before I came here tonight, tried to draft up a motion so I wouldn't have to do it on the spot. Just for this matter, but I would also suggest that early in the year, next year, maybe in January, we think about other ways for making sure that we meet our attorney's primary point, which is that any information that any of us consider with respect to any application, all of the rest of us have the opportunity to consider on a timely basis. The applicant has the opportunity to consider it timely, as does the general public. I think that's the main point. What particular procedure we use, I think there's lots of flexibility, and we might want to give it some more thorough thought, but I think we should establish a clear procedure tonight for what we're going to do on the application that's before us, and it's the point of this agenda. And I have a proposal, but Joe, you seem to have a comment. So
well, I agree with you, and I think we should do that. I want to make one more comment that just before we leap into that, which is that I've emailed Maureen many times with requests, either stuff I found out on the internet or requests for additional information from an applicant. And it has never been, it's always been to help the applicant. I mean, in a sense, we're a body that makes sure all our I's are dotted and our T's are crossed in terms of compliance with the ordinance. And 90% of what I've ever sent to Maureen in advance of a meeting is questions that I know are going to come up. And I don't want the applicant to be blindsided. I want the applicant to be prepared to answer these questions. And for example, the aging of the court, and I was pleased to find out that the material that I found was not applicable, but I think that Phil did a great job of explaining how the court then would age and what we could expect from it as a response to that question. And so I would be very hesitant to really put much of a limit on what we can send to Maureen to request more information from the applicant, even right down to the wire, because, I mean, let's face it, these guys, you know, the design professionals are preparing stuff at the very last minute and getting ready.
So that's a comment towards timing.
That's coming toward timing and just in general. I mean, I've always understood it that Maureen is the clearinghouse for any requests for additional information or anything we found out. And I just also want to make it clear, I never do research or try to find out about stuff in order to stymie an applicant. I only do it to make sure that the application makes sense and to try to help it along.
Any other comments from the board? Then at this time, did I miss anyone? No. And this time, if there's any public comment? No? Okay, thank you. Then you said, Elaine, that you had a motion to consider?
I do, because it was recommended to us that we do this in a formal way, at least in response to this particular applicant. So, motion for the board to consider Findings of fact. 517 Ocean House Road LLC, through its legal counsel, has made certain procedural requests in connection with the planning board consideration of facts and materials presented by the applicant. 2, the planning board has consulted the town attorney in connection with such requests. Therefore, be it ordered that based on the plans and materials submitted and the facts presented by 517 Ocean House Road LLC, requesting various amendments to the previously approved site plan and resource protection permit for the Rudy's project at 517 Ocean House Road, the planning board hereby charges the town planner to collect supplemental information in connection with this application in accordance with the following procedure. 1, any planning board member may request the town planner to obtain or distribute additional or supplemental resource information in connection with facts or materials presented by the applicant. 2, the town planner shall provide photocopies and/or a list of website links of all such resource information collected to all planning board members, to the applicant, and to the public as part of the public record of this application in advance of any public meeting in which a decision may be made by the planning board.
Thank you.
Pretty good.
Any comments or?
Did you reread 1? Did it talk about only the planner doing that research in point number 1? Or
Collecting,
was
I
it
believe I heard.
about the board? It's not just the planner?
Planner will be collecting.
It says any planning board member may request the town planner to obtain or distribute additional or supplemental resource information in connection with facts or materials presented by the applicant.
Okay, so that could be just obtained by a member and distributed by the planner.
That's the intent, yes.
Okay?
Elaine, the last point, the timing coming up on a decision, a meeting in which a decision is made, and the information be submitted right up to that meeting without a time.
That was the standard that the town attorney suggested, so I took it directly from that. And he just said, in advance of any public meeting in which a decision may be made. So that if a decision is going to be made impacted by that material, it has to be distributed in advance.
In advance without a specified vote.
Correct.
I'll second her motion.
Okay, thank you. All those in favor? Okay, that is unanimous. All right, this special meeting then. Do we have to formally close it?
Motion to adjourn.
Okay, a motion to adjourn, please.
Motion to adjourn.
Thank you.
What about sidewalk? Did we talk about point number, site visit, point number 1?
That's not on tonight's agenda.
Okay, we have adjourned. Thank you.
Did you want this morning?
Yes, I do.